Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I have the best subscribers of anybody on YouTube. I am convinced of that. But of course, I'm always willing to have more. So, if you're new here, please feel free to jump in here and click that subscribe button and touch that notification bell, because there's usually some good stuff here, and sometimes we even have a little bit of fun. So before I get into why I have such great subscribers, I want to talk about lawyers in general, and to a certain extent, lawyers specifically who handle criminal cases. Lawyers who handle criminal cases tend to have a bit of a reputation. And the reputation that they have is that they are colorful, and they are frequently prone to courtroom antics. And those courtroom antics sometimes help their clients, sometimes hurt their clients, and sometimes wind up with them being fined for contempt of court. And sometimes even winding up with them having trouble with the state bar. But these colorful characters who are lawyers, they are part of a rich and very long history. Now, this fellow is a guy by the name of William Kunstler. And William Kunstler was a lawyer from the late 60s. So the first time I saw this character on the evening news, he was representing the Chicago 7 after the 1968 Democratic Convention, which went very badly wrong for Mayor Daley and the entire Chicago police force, but that's another story. Basically, when I saw William Kunstler and watched him and his antics in court, or learned about them and saw him as he gave interviews, my initial thought was, does he share a hairdresser with Bozo the Clown? Probably not a charitable description, and probably one I'm not real proud of, but that's what I thought. The guy obviously has never met a comb or a brush. But he was very effective, and I think he did a very good job of representing the Chicago 7. And then there's this fella, F. Lee Bailey. You may know F. Lee Bailey from the O.J. Simpson trial, but F. Lee Bailey actually got his start, his big break, in defending a guy in Ohio by the name of Sam Shepard. And Sam Shepard was charged with the murder of his wife, and actually it became the basis for the television show The Fugitive. You may remember that in the television show The Fugitive, the character who was running from the law was a doctor, right? Well, in this particular case, in the Sam Shepard murder case, he had been charged and convicted of the murder, and the issue was pretrial publicity. Given the amount and type of pretrial publicity, it was a little bit like sticking your foot in a pool full of piranha and expecting not to get bitten. And that is essentially what happened. The jury didn't take very long in convicting Sam Shepard, and as a result, it went all the way up to the United States Supreme Court before the conviction was reversed and he got a new trial. So, in his later years, as I mentioned, he did do some work for O.J. Simpson, and then after that, while he was representing a drug dealer down in Florida, he managed to misappropriate some funds, or at least allegedly misappropriated some funds, and it wound up getting him disbarred in Florida and then later in Massachusetts. And then there's this fellow, Clarence Darrow. He's sort of the grandfather of all of these great criminal defense lawyers. Darrow defended the defendant in the Scopes monkey trial. Now, those of you who don't know your history may know that there was a law against teaching the subject of evolution in the earlier part of the 20th century, and that the Scopes defendant was a fellow who had violated that law, and Darrow defended him. And during the course of an argument at the bench, Darrow said something that miffed the judge. And the judge said, "Well, I hope Mr. Darrow did not intend any disrespect." And Clarence Darrow said, "Well, the court can always hope." which was probably not the wisest thing to say. It got him fined $100 at a time when $100 is probably a lot closer to what $1,000 would feel like today. But at any rate, he was a colorful character and he did a lot for his clients, very well thought of, sort of a old day Jerry Spence, a Jerry Spence of his time. But there is this sort of ethic among really outstanding criminal defense attorneys that they have to do everything necessary to win. Not always a bad look, but also not always a good look. Which brings us to my great subscribers. They pointed out that I was being much too charitably, I was dealing with Shannon Smith, who is representing Crumbley, much too charitably. They said that she's very well known in Michigan and that she has a reputation, and that apparently she represented this fellow named Larry Nassar. Now, if you're not familiar with that case, I can't describe it here, but you can get a clue about it by looking at Smith's website. So, and it's called abusedefense.com. But when I saw her in the courtroom, and of course the cameras are pulled way back, and obviously she's wearing makeup, she looks like she's about 25. Okay, she looked to me like she's about 25. I'm sure to the ladies in the subscriber pool, they obviously saw through the fact that she was not 25, and it's apparent that she isn't 25. But the cameras in the courtroom don't do her justice. Now, this photograph, which I found online, I always wonder what it is people think photos like this do, because when I see this photograph, I am immediately reminded of this photograph. And neither one of these photographs is something I would want to be associated with, simply because they make you look a little bit unhinged. I'm sorry, that's just my opinion. That's what I think. Now, obviously, she thinks this makes her look good. More power to her. But yesterday, in representing Crumbley, she went way off script. So let's talk first about a motion in limine. I've talked about a motion in limine before, and again, limine is spelled L-I-M-I-N-E, not L-E-M-O-N-Y. A motion in limine is designed to prevent information, evidence that the other party has from being admitted. And usually, in this case, in this particular case, it was evidence of Ms. Crumbley's affair during her marriage. And the purpose, obviously, is to keep out information that is far more prejudicial, right? Meaning that it suggests a decision on an emotional level rather than a logical level, much more prejudicial than probative, because her being somebody who sleeps around doesn't necessarily prove that she's negligent, except maybe for her personal hygiene. I think there's probably a lot more risk to someone. But at any rate, in this particular case, she had won that motion in limine, and the court had agreed to keep that information out. Then this happened.
Recently, within the last couple of months, in December, you did this 3-hour interview.
Correct.
It's fair to say that throughout all 3 interviews, you tell law enforcement repeatedly that you have memory problems, correct?
Correct.
During the hours of interviews you've had with law enforcement, they have given you different pieces of information against Jennifer Crumbleys, correct?
Correct.
And when they ask you the same questions over and over and over, you can tell sometimes they don't like the answers they're getting from you. You can tell that. Is that a yes?
Yeah.
Okay. I need you to be loud. Okay? Thank you. So when you can tell they don't like the answers, you keep talking to them, correct?
Correct.
And when they've been interviewing you, they have started to talk to you about things like your job and your benefits, correct?
Correct.
Largely, what has influenced you to change what you say, what you said initially, is because police have talked to you and made you change your mind, correct?
It had to make me, from my original, that more information is needed.
Right, so my point is, you talked to them at first, back in December, right after the shooting happened, right?
Yes.
And then law enforcement met with you 2 more times and gave you information, right?
Yes.
And they told you that if you were helping Jennifer Crumbly, you would be in trouble.
Judge, objection, we're getting dangerously close to what defense counsel has sought to exclude, and I need to be able to redirect.
Yeah, let's be careful.
Well, the door's open.
Okay, let's be careful.
If counsel is going to lay the implication of a certain reason,
Well, you're asking whether law enforcement threatened him in order to get him to lie?
Yeah.
that's
So she impeached the state's witness here very aggressively, and she drew an objection. And the objection is, look, you can't use this motion in limine as a sword and a shield. You can't come in here and impeach this guy with vague comments about you were afraid of something, or the state held this over you, without disclosing what it is that the state held over him or why it might be relevant on other issues. And of course, the judge agreed. So the judge says she's opened the door, the state can retaliate, and then the state did something very smart. One of the things that frequently happens when the state wins a case like this and somebody gets sent up to the big house, one of the things that happens is the defendant will always file a motion for post-conviction relief, meaning basically something happened during the trial that made my trial unfair. And of course, one of the most common ways is through ineffective assistance of counsel, essentially saying that I have a right under the Sixth Amendment to have counsel for my defense, and this lawyer doing this job in the way that she did it fell well below the bar for proper defense of a defendant. And you can get there sometimes when somebody does something that is just completely negligent, beyond the pale, something like that. Well, the antidote to that, and the state's antidote to that, is A, you agreed, you didn't object at the time, you didn't tell your defense attorney to stop, and B, that it was trial strategy. So that's essentially what Shannon Smith here says. But because the testimony can cut both ways, it can both humanize the defendant as well as demonize the defendant, the state did something very smart here. And what it did is it said, we want to voir dire the defendant. And of course, voir dire, I mentioned before, voir dire is French, it means to speak the truth. And basically, you put the defendant under oath and you ask her questions. Now, you can't ask her questions about guilt or innocence. Were you the gunman on the grassy knoll in Dallas? You can't do that kind of thing. But what you can do is what the judge did here.
thank you, Judge.
Well, raise your right hand. Do you swear or affirm the testimony about to give is the truth, so help you God?
I do.
Okay, you can put your hand down. Mrs. Crumbley, I want to make sure. This has been kind of fast and furious here, right? Okay, so I want to make sure you know what was going on. A year and a half ago, there were some motions that were filed about keeping some evidence out.
Correct.
I guess I would suggest that now that we're here 2 years later and there's more information about the case, I can't even tell you if I rule in the same way, knowing everything I know now. But that being said, I want to make sure you understand what your lawyer said, which is that I previously ruled that in and of itself, the fact that you were having a romantic relationship with this man, to me, was not evidence in and of itself of gross negligence or dereliction of duty. Therefore, I granted your attorney's motion to keep that information out of the trial. You understand that, right? Okay, but now this gentleman is being questioned about why he did or didn't make certain statements to the police. And your attorney has indicated in front of the jury that he might have some motives, or maybe he's been threatened by the police. And she has said to me that she wishes to pursue that line of questioning. And I want to make sure that you are supportive of that.
I trust her, so yes.
Okay, so you understand that then we're going to crumple my order up about that and throw it in the trash and go forward.
I do.
You understand that?
I do.
And you agree?
I guess, yes.
Okay.
And of course, there's a dictum that says when you're winning, you keep pushing forward, and you try to get every last little bit of everything you can get out of the judge. When rulings are going your way, you may as well ask for more rulings and better rulings, and that's what the prosecutor does here. Let's see what the judge does.
Judge, I think I should make a record so the defendant and perhaps counsel knows for sure. It's not just an affair with one man that was uncovered. There's web searches now. There's trips during work hours. There's when she was on actual work trips with other individuals. It's not just this person. It changes the tenor of the entire trial.
I don't think that that's appropriate.
So what the judge is doing here is she's trying very hard to protect whatever verdict comes in. If the verdict comes in favor of the state, she doesn't want it reversed because irrelevant things were later used to impeach this witness, whether he knew or didn't know about all these other things. And that is probably going a little bit too far because that isn't what Shannon Smith is impeaching him with. So the judge is being pretty cagey here. That's pretty good. I've been a little critical of her in terms of not controlling the courtroom, but that's a great evidentiary ruling, and she did the right thing here. So now you have an informed consent to essentially putting in front of these 12 jurors information about her sleeping around. Now, one way that it could humanize her is if there is a woman or two on this jury who may have strayed from her marriage, who maybe got divorced because of that and is now happily married, but realizes that sometimes people step out of their marriage. And, sometimes it can be for good reasons, particularly if people are beaten or if they're isolated or emotionally abused. Or sometimes it can be for really bad reasons, like they're just, they just have needs that they think aren't being met. Whatever it is, it could humanize her with several of the women. It probably won't humanize her with any of the men. They're probably likely to be very judgmental about that. And I say that because I would be very judgmental because my wife, not my current wife, obviously, but my ex-wife, stepped out on me and basically destroyed the trust in that relationship. And because of that, I take a very dim view of it. But I'm different, I think, than many people. Many people might go, doesn't make her guilty. And indeed, it doesn't make her guilty or doesn't make her negligent. So it could cut both ways. It could humanize her, but it could also demonize her. Particularly if you get somebody who just is very, very judgmental and is unable to put that behind them. And of course, if you were going to do this, one of the things that you should have done in voir dire is to ask the question, would something like this affect your ability to be fair in the trial? And you get an assurance from the jurors that they're not going to hold something like that against her. But because she had the motion in limine and assertedly didn't have to worry about that, that probably didn't happen in voir dire. So it presents an issue that could become a problem for this particular defendant in the jury room. I think it is always unwise to act unprofessionally. I think it's always unwise to do anything that annoys the judge because, as I've said here before, the number one rule of trial practice is don't honk off the judge. If you honk off the judge, things are going to go against you. Rulings that could be really close and you might get the benefit of the doubt on tend to go the other way when the trial court feels like you are abusing the process. So, again, not really criticizing this gal. She may have an excellent trial strategy for why this is coming in, but apparently it wasn't just an unthought about or negligent act on her part. Apparently she says it's trial strategy, and we'll just have to see how well this plays with the jury. So that's what I have for you today. I want to thank you all for watching. If you have the opportunity today, do something nice for folks. Maybe you can take somebody to lunch, take a coworker to lunch, or bring back, if you go to lunch, bring back something for somebody. There are lots of ways we can make people's lives better in incremental ways. that eventually make all of our lives better. Thanks for watching. And again, if you have the opportunity, do something nice. And always come back and see me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.